Welcome to Bankruptcy, Through the Looking Glass, with Barry Levine.
Welcome to Bankruptcy Through the Looking Glass, with Barry Levine. Today, we're talking about the hidden frustrations bankruptcy attorneys face. I'm your host, Abigail Vaca. Welcome, Barry.
How are you, Abigail? It's a beautiful morning, but freezing here in Beverly, Mass.
Likewise, it's about 14 degrees here.
I think we're the same temperature.
Right. All right. Well, let's jump right in. What are some of the most frustrating aspects of handling bankruptcy cases that people sometimes outside of the field wouldn't necessarily expect?
People, unfortunately, nowadays, listen, I've been representing debtors for probably longer than you've been on the planet. And, people with Google, everybody has their law degree, their Google law degree, or they spoke to their friend spoke to a friend who went bankrupt. And everybody knows. I was chatting with somebody on the phone the other day, and she saved me a lot of time and not having to explain to her about what a Chapter 7 was. But she told me straight off, well, she's done her research, so I didn't bother explaining everything. And, it's like, why bother? If you knew, what can I tell you? But very often, and my assistant Kathy could probably, she deals with very often the clients more than I do. The process itself is very simple, what you need. And there's now we have a program, a software that we use called Best Case, that each client has their own portal. This is news to me. And they can upload, if we need for instance, we need 6 months worth of their pay stubs. They can upload that. They can upload their all the documents that we need, they can upload. Yet very often they'll still take a picture of a document, which does us no good. I need a, PDF or something like that. Or they'll do the stuff piecemeal. It becomes, it becomes a torturous process where it really shouldn't be. The only time it's a little more complex from my perspective is if it's a Chapter 13 and now you have to deal with their numbers and figure out what their disposable income is going to be that they would be paying their creditors in the Chapter 13. But I find that it's, too often a lot of the debtors tend to think too much. There's not a lot of thinking involved with it. It's a fairly simple process. It's like, I look at it as, would you go to your doctor gives you some line of bullshit, you need this, that, and the other thing. You're going to bother checking them? I'm no different. I've been doing this for a long time. I can tell most of the people who come in here when I get a sense of what their assets and liabilities are and this, that, and the other thing, what their case is going to be. It's, I shouldn't give away trade secrets. It's aside from having to sacrifice the lamb, but, it's no great thing involved with it. But, it's more often that the clients can tend to make it more difficult than it's totally necessary. And I hear most of that from, like I said, my assistant Kathy, who, pretty much puts together the petitions for everybody, for the clients.
In any way, what role does dishonesty or lack of financial transparency play in making bankruptcy cases more frustrating for attorneys?
Well, like I think I said, it's what if I don't know, there's nothing I can do about it. There was a time where back in the late 80s here, every old mill town in Massachusetts, the downtowns were being redeveloped into condos. And this was right before the banks all collapsed in the late 80s. And I had a client who had properties I found out later, all over the state. And we filed bankruptcy. And there was no way at the time, like now, if I need to check a registry of deeds here, for the most part, I can sit on my tuchus here and go on the computer and find what I'm looking for. When this guy filed the bankruptcy, that would have meant going a tour of Massachusetts to every registry of deeds in the state. At the time you were getting paid $1,000 or $1,500 for a bankruptcy. Yeah, I'm going to schlep all over the state to check the registries of deeds. So we filed the bankruptcy for him, and he forgot. Must have been 6 properties that he owned. They were all encumbered. It really didn't matter. But he forgot these properties. I forgot what city they were in, someplace in the western part of the state, like in another world. And some attorney berated me because he had left it out of his petition. And it's like, well, was I supposed to check the registry? It wouldn't even occur to me he had property. I'm in, at the time, I think my office was in Lynn, this was someplace else. But that's, things like that. It's, as to dishonesty, if they're going to be dishonest, there's nothing I can do about it. If they have money in a sock someplace, if every one of my clients that some creditor thought had money in a sock, if they actually did, I'd be on a nice warm island, a millionaire. But it never happens. I mean, they're not that savvy. You have people who have successful businesses. I mean, I know from my own perspective, who puts money away. And, you would think they're making a lot of money and they put money away for when the shit's going to hit the fan. Never happens.
Got it. Okay. So are there any particular bankruptcy laws or regulations that you think are unnecessarily complex?
Nowadays, they consider a household's income. Years ago, it was just whomever the debtor was and the debtor's income. The problem I have, and I've had a number of cases recently, I got a lot of problems, my ethnic heritage, is very often a wife will file bankruptcy and all of her debt, her husband's a high earner and he's not filing. He's had nothing to do with the debt that she has. Why should he pay a dime of his money to her debt? But that's what, it's probably 25 years ago now, or 20 years ago, it used to be it didn't matter. But now, that's the one thing that annoys me. But otherwise, complex, nah, not really. It's, there's certain things you would expect a young attorney when you file a bankruptcy for somebody and you go to the 341 meetings. It's like you need to provide the trustee with 60 days worth of their pay stubs. If they own a real estate, the mortgage, the homestead, a copy of the appraisal, the same thing with the cause. And yet you find a lot of young attorneys, they seem to be clueless to all that stuff. I mean, and that's, to me, fairly simple. How could you file a bankruptcy and not have a blue book value of your client's car? What, are you going to make it up? Same thing with the real estate. I mean, the clients will say they know the value of I need an appraisal. I mean, this is what the trustee is based on, that the fact that you think it's worth this much, and then the other thing is Zillow sometimes bears no relation to reality. And then a town or city's assessment is usually of another world too. So, very often the trustees really ask for an appraisal.
What about creditors? How do they complicate bankruptcy proceedings? And do you have any strategies that you use to navigate those challenges?
Well, I learned a long time ago that I don't bullshit creditors. I tell them there's no money. If you want to sue them, have a nice day. If they file a bankruptcy, there's nothing you're going to get. There's no utility in, I've found over the decades that the creditors really just want someone to talk to. The typical debtor doesn't answer, especially with caller ID. I wish I had that when my mother used to call every Sunday. I'd never answer the phone. With caller ID, they never answer the phone because I tell my clients, I say, when the creditors call you, refer them to me. Happy to tell them I've been retained. And, up to the date they file, they complain about the phone calls. And it's like, why are you not referring them to me? Well, it's because they're not answering. And unfortunately, you very often deal with, there are a number of debtors who, when they talk to a creditor or somebody that's dunning them for money, want them to feel good. So they'll make some sort of ridiculous promise, I owe you $8,000, I'll pay you $5,000 in 60 days and the balance in 30 days. Never comes to pass. It never happens. And all you do is piss off the creditor. It's much easier to say to the creditor, I can't pay this off. I need 2 years or 3 years. and then you walk in like a hero in 30 days and say, here's the full amount. If that ever happened, it would be the first time in my career, but it could, but the thing is, I don't, I look at the creditors, I'm doing them a favor. There's no, like I said, if they want to waste money on litigation and things like that, I'm not going to dissuade them. I know for a fact that the case is an assetless case. They're not necessarily a high earning debtor, and they're going to get, here's a Yiddish word you can all look up, chai kak, which means basically shit. And why bother? I don't make them any promises, and then the thing is also, the collection process itself time is so built into it that if somebody, for instance, I have lots of people that come to see me, and I don't know how, but they're still making the minimum payments on their credit cards. And at that point, first off, it's mishigas to continue paying them. If you're going to file a bankruptcy, you may as well buy lottery tickets and maybe you win. But at that point, the creditor is so far away from suing you that we probably have the case filed before they even get around to sending the case to a lawyer, because the collection process, between the creditor, the collection agency, the collection attorney, it's built in. Like I tell clients, I say, listen, when you get these letters that say, if you disagree with the balance due, send us a notice within 30 days. Well, shit, it's a credit card. Either you used it or you didn't. It's not like, God forbid, a car accident where my neck hurts. Well, I'm doing gymnastics, but my neck hurts and I want $5 million. It's black and white. And so they give you the opportunity to send this letter. And the letter just has to be a simple one. I dispute the balance due. And the insanity now is, because of all these crazy lawyer-induced laws involving collections, they have to send you a copy of every invoice that you've ever had with the credit card. So now you've disputed it, and they then send you all this shit, and okay, you're still not sending them a check because you don't have the money. They send it to a collection agency, and the collection agency sends you the same letter. Doesn't cost you to send the same response again. Just make sure to change the address and the date. And when you do that, they then have to go to the creditor, get all that information and send it to you. Now, when you basically don't ignore that, they now send it to a lawyer. And very often the lawyer, for whatever reason, is in some other state. If I'm in Massachusetts, who gives a shit? If they're in Michigan, what are they going to do to me? So now the lawyer has to send you that same letter. You respond. Lawyers send you copies of all the invoices. And then eventually they file suit. How long do you think this takes? This takes a long time. Now they file suit. And when they file suit, all the invoices that you have now, if you use the backs of the paper and a copy, it's not a bad thing, saves you on paper. But all the copies that you've had, they send you another copy of all the invoices. Client just came in, there was a stack like this. It was an American Express account. I couldn't stop laughing. And then how long does this take to get a judgment against you? Year. And a judgment doesn't mean that you get paid. So, it's built in to just be jerked around, for lack of a better word. The only problem that you find nowadays is that because people are so free with giving out their email addresses and cell phone numbers, that they start to nudge you right away. If you miss a payment, suddenly you'll find out the next day by an email. And I had a solution. My mother, before she died, I had gotten her a cell phone number. I started to give that cell phone number out to the creditors. Rang in the closet. Nobody bothered me.
That's funny. Okay, so it sounds like there are a lot of frustrations. I'm curious if there are any procedural changes that you would advocate for. And, despite all of these frustrations, what keeps you passionate about practicing bankruptcy law?
Ooh. Guess I look passionate. What I would like to see change, what really annoys me is that everything is done electronically. And when I file a pleading, every attorney who is involved in the case automatically gets a notice. But what happens is I then have to file very often a certificate of service saying I've served all these same people who've already received the notice. It's stupid. There's so much paperwork now that they should be trying, there are cases where I have to file amended plans, which if somebody would call me, I could just make a change. It's typographical. It's not issues of how much you're paying and this, that, and the other stuff. It's picayune bullshit. But, you're dealing with a certain type of person that this is more important than reality. Very often the stuff that you have to file an amendment for has nothing to do with what the plan payment may be. That doesn't change. And since nobody, the typical creditor, you wonder once you file a case, nobody reads this shit. It's not as if, when I file a plan in a Chapter 13 or even a Chapter 11, you think anybody looks at that crap? The only one who looks at it is the government people who get paid to do this shit. Otherwise, I write things to entertain myself. I don't write like a lawyer typically. So, that's that. Otherwise, it's boring. What keeps me going? I tell you, it's as busy. I've been doing this now. It's over 44 years representing debtors. I used to have a lot of hair. There's a picture of me. I don't know if you can see it up there with the hair. What keeps me going is I like making the clients, when they come in here, they feel better when they leave, because a lot of them don't appreciate, that all we're dealing with is money. That's all it is. It's not their health. It's not this, that, or the other thing. It's money. And the credit card companies and the banks, they can afford to take the loss. And, so many of them, they thank both Kathy and I. They come in so anxious. And, to me, what are they going to do? Sue you? Oh, my God, they're going to sue me. Big deal. Life goes on. There are a hell of a lot worse things. Getting a flat tire is a hell of a lot worse than being sued. It's like, you got to call the AAA. You got to deal with it. And then I learned that my fancy electric car made by VW doesn't come with a spare tire. Silly me. I looked for a spare in the trunk. There wasn't one there. There was something to blow air into the tire, which was shredded.
Well, I appreciate that you do all of this with humor, too. Thank you so much for joining me today.
Hey, a pleasure. A pleasure. Zeitgesund, everybody.
Thank you for joining us for the Hidden Frustrations Bankruptcy Attorneys Face. To connect with Barry, visit levineslaw.com. And don't forget to like, subscribe, and leave us a review.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.